This is Bloomberg Law with June Grasso from Bloomberg Radio.
The Supreme Court deadlocked 4-4 on Thursday in a major case over the separation of religion and government, thwarting an effort to create the nation's first publicly funded religious charter school in Oklahoma. The tie was possible because Justice Amy Coney Barrett recused herself from the case. The Supreme Court's one-sentence order didn't reveal which justices were on which side of the divide. But during the oral arguments, it seemed apparent that 4 conservative justices were likely to side with the Catholic charter school, and the 3 liberal justices were likely to side with Oklahoma. Here are Justices Brett Kavanaugh and Sonia Sotomayor.
And then you come in and you say, oh, we're a religious school. It's like, oh, no, can't do that. That's too much. That's scary. We're not going to do that. And our cases have made very clear, and I think those are some of the most important cases we've had, of saying you can't treat religious people and religious institutions and religious speech as second class in the United States.
Because the essence of the Establishment Clause was, we're not going to pay religious leaders to teach their religion. That is and has always been the essence. And here we're paying Catholic leaders, Catholic teachers. You can only be a teacher in this school if you're willing to accept the teachings of the Catholic Church.
That left Chief Justice John Roberts as the pivotal vote, and the chief distinguished the Oklahoma case from past Supreme Court decisions backing the use of public money for religious schools, saying there appeared to be more state involvement in this case.
Trinity Lutheran, Espinoza, Carson, those involved fairly discrete state involvement. In Trinity Lutheran, they're going to pave put wood chips on the playground. In Espinoza, it was a tuition credit. In Carson, again, tax credits. I mean, this does strike me as a much more comprehensive involvement.
The split leaves in place the Oklahoma Supreme Court decision blocking the religious charter school and leaves open the question of whether states with taxpayer-funded charter school programs are constitutionally required to incorporate religious institutions. My guest is religious liberty expert Stephanie Barkley, a professor at Georgetown Law. How important is this case? What would the consequences have been if the court had allowed the nation's first faith-based charter school?
So there's really 2 questions there. The one question is, if the court had ruled in favor of the faith-based charter school, how important of a decision would it have been? And that would have been a landmark case. It would have been the first time that we had a faith-based charter school and would have had some significant implications, probably not just for faith-based schools and charter schools, but potentially in other states as well. Now, there's the second question, which is, okay, well, how significant is the court's decision, given that it's just, a very brief order without an opinion, 4-4 split, affirming the lower court decision? And at that point, the answer is a matter of precedent. That precedent is not particularly important. It's not going to tell us, much about anything besides the fact that they're affirming this case. There weren't 5 votes to reverse the Supreme Court in Oklahoma. And in that way, it's going to be of limited precedential effect.
Does this case reflect tension between the First Amendment's 2 religion clauses, the Establishment Clause and the Free Exercise Clause?
I don't think there is a tension between the 2 religion clauses, and the Supreme Court emphasized that in its recent case in Kennedy versus Bremerton School District, that largely those clauses work together in a mutually reinforcing way. But this case does highlight the way in which you could get a different outcome under either of those clauses, depending on whether we're dealing with a private school or a government school. Because if it's a government school, then it is pretty clear that government doesn't get to run religious programs where it's preferring one type of denomination over another or setting out religious liturgy, and things like that would be prohibited under the approach to the Establishment Clause the court has been taking post-Kennedy, where it looks at the 6 historical hallmarks of an established religion. Now, if it's a private school, then the Free Exercise Clause is the relevant focus, and the question is, can the government exclude the private school? And the trajectory of cases that it has had in Trinity Lutheran, Espinoza, and Carson makes pretty clear that the court thinks the free exercise clause prohibits government from excluding religious schools just on that basis. So it is a case that highlights different outcomes depending on the government versus private nature of the entity.
We don't know how the justices voted. The arguments suggested perhaps that the Chief Justice was the pivotal vote who might have gone with the three liberals.
I think that that's probably the most likely outcome, that you had the Chief, Justice Sotomayor, Kagan, and Jackson did not feel comfortable overruling the Oklahoma Supreme Court. And then you had the other four justices, Justice Thomas, Alito, Gorsuch, and Kavanaugh, that probably would have ruled to overrule the Oklahoma Supreme Court. And then, of course, Justice Barrett is recusing. And, of course, because they only got to 4-4, that means it's an automatic affirmance of the previous judgment.
Were you surprised that there weren't 5 votes for the religious charter school?
I think it's unfortunate that there weren't 5 votes. I think it's possible that the chief was concerned about lack of percolation. This is the first case of its kind. There aren't other cases that have grappled with this yet. So hard to read the tea leaves about exactly what was the worry for him, but I think it's promising that this court doesn't have an opinion from the chief sort of staking it out in a way that suggests that this would be a permanent position, but leaving the door open to future challengers and future cases.
So then do you think that states that fund charter schools should be required to fund religious charter schools?
I think that if a state is operating such that they're using the label of like a government school, but they're really treating it like a voucher, then I think probably the functional analysis matters more than the labels do. But if the government is really operating charter schools like other government schools, then I think government should be entitled to make choices about running secular government schools. So it really just the devil's in the details of how is that particular government operating its school system? How much oversight is there? Is it being even-handed in the way it's approaching that oversight with, the different types of charter schools and public schools? Those are all going to be questions that will be certainly relevant to the court should a case like this arise again.
The 4-4 tie was a product of Justice Amy Coney Barrett recusing herself. So since it's not a nationwide precedent, is it likely that proponents of religious charter schools will simply try again in a case where Justice Barrett can sit on the case?
So I think that is certainly not foreclosed by the court's opinion in this case, and a possibility at some point in the future. I think the most likely next case that you will see in the school choice movement is St. Dominic Academy versus Macon, which would be coming out of Maine. It's possible other cases could too, but this is one that is already in the court system. And it is essentially Carson 2.0. So Maine, the same government that the Supreme Court ruled against in Carson, revised their laws when the case was sent back down to try and find other creative ways to keep faith-based schools out of what is not a charter school system, but it has always included private schools and operates more like a traditional tuition voucher program. And there are faith-based schools that are challenging that right now, and that's making its way through the court system. So I think were the court to take another school choice sort of case, I think that's a more likely next step. There are no cases right now percolating that I'm aware of where there's another faith-based charter school that, has been approved or requested to be created and been denied, and that they're suing over that right now.
Has the Supreme Court in recent years expanded religious liberty rights over other rights?
I don't think that I would say they've expanded religious liberty rights over other rights, but they have certainly given a lot of attention to and been solicitous towards religious claims. Although there are certainly religious claimants that have been before the courts that didn't win their case, and this is another one. So I think this is a court that takes balanced and cautious approaches while still being sympathetic towards religious liberty claims and wanting to ensure that it's providing robust protection under our First Amendment.
We're waiting for 2 more decisions from the court in religion cases. Tell us about those.
One is a case called Mahmoud, and that is another case in the educational context coming out of Maryland. And this is a case where this school district has instituted a policy where books are being read to children down to elementary school and preschool that deal with issues related to sexuality, gender identity. And there are parents who aren't objecting to those books being read broadly, but would like to be able to opt their children out. And the school in that case has said that they are not allowed to opt their children out. Their only option is to drop out of school altogether if they don't like that policy. So the Supreme Court has heard oral argument in that case, and it seems likely from oral argument that they will rule in favor of the religious parents. You have Muslim parents, Jewish parents, and Christian parents in a coalition in that case. Another case is the Catholic Charities case that the court heard before that. And that is a case where there is a question of whether a Catholic institution can qualify for a tax benefit in the state. This decision from the state Supreme Court had said that if the Catholic groups were engaging in more typical religious behavior and were organized in a more typical way and were doing things like proselytizing to other individuals as part of their ministry, then they would qualify for the tax benefit. But because this Catholic charity does not proselytize and that's not part of their mission, they would serve people of their religious groups or not all alike, and they don't try and convert people to their theology. Because the Catholic ministry doesn't do that, on that basis, they don't qualify for the tax benefit. And that was another case where the court seemed quite skeptical of the government action. Justice Kagan in that case even asked, isn't it pretty clear that government doesn't get to tell people what ordinary religious practice is and which practices are approved and which are not? So, it's even possible in that case the government might be facing unanimous defeat. Certainly something is likely that they could get 8-1 or 7-2 votes in that case.
And we'll find out the results of both those cases before July. Thanks so much for joining me, Stephanie. That's Professor Stephanie Barkley of Georgetown Law. Coming up next on the Bloomberg Law Show, families of the Buffalo mass shooting victims want to hold social media platforms liable, and they're asking a New York appellate court to allow their suit to go forward. I'm June Grasso, and you're listening to Bloomberg. It's been 3 years since a white supremacist opened fire inside a grocery store in Buffalo and killed 10 people. The 18-year-old shooter pleaded guilty to all state charges and was sentenced to 11 concurrent life sentences. Survivors and families of the victims have been trying to hold social media companies responsible for publishing racist content that allegedly motivated the shooter to commit the hate crimes, targeting people in a historically black neighborhood hundreds of miles from his home.
Our case is fundamentally about the isolation, obsession, lack of impulse control, and desensitization resulting from the neurological and psychological trauma inflicted on a teenager's brain by a highly addictive social media product.
The social media companies, which include Meta, Discord, Snapchat, and Twitch, say Section 230 of the Communications Decency Act protects them from liability for third-party content. But the trial judge ruled that the lawsuits could go forward, and both sides were in a New York appellate court this week as the companies tried to get the suits dismissed. The victims' families argued that the algorithms used by the sites to deliver content should be considered products under the state's product liability law, but the companies argued that non-tangible things can't be considered products. Here are the attorneys for the victims' families and Meta.
Anytime a manufacturer places a dangerous product into the stream of commerce that they reasonably know creates an unreasonable risk of harm to the public are liable under New York State products liability law. It's plain and dirt simple.
And there are two sort of foundational problems here that get us outside of the realm of traditional product liability. One is that communicating intangible information is not a product, and the second is that services are not products. And here we have both of those things. Product liability law is geared to the tangible world.
My guest is Eric Goldman, a professor at Santa Clara University Law School and co-director of the High Tech Law Institute. Eric, can you tell us about the allegations of the plaintiffs in these cases?
The case involves the mass shooting in a Buffalo supermarket by a white supremacist. And the basic gist of the claims is that the shooter was radicalized on Facebook. And so in order to fit that into legal doctrines, there's a variety of different claims that the victims and families have made in order to explain what's wrong with that. Why does that actually create legal rights for the victims? So some of those include a claim that Facebook was negligent, that it should have done something different to protect the victims. And some of it is based on what we sometimes call products liability, that Facebook is a product that is dangerous, and as a result, any harm that's caused by a dangerous product can be attributable to the supplier of that product.
Are the plaintiffs bringing it under the product liability law in order to get around Section 230?
No, Section 230 is a defense, whereas the plaintiffs have to still figure out a claim that actually fits their facts. However, they do want to pick claims that are not preempted by Section 230, which says, in short, that websites aren't liable for third-party content. So the idea is that the plaintiffs are arguing that they're not suing to hold Facebook liable for the third-party content. They're suing based on Facebook's contribution to the radicalization of the shooter.
When you think of product liability, you think of tangible objects, a mechanical device that injures you, something like that. Has a New York court ever found a streaming service or social media to be a product under the state's product liability law?
For decades, there have been legal theories that have held that the supply of physical items that are at risk of causing physical injury are liable for those physical injuries. And one of the classic old cases involved exploding Coca-Cola bottles. And if you didn't manufacture and fill the Coca-Cola bottle properly, it could literally explode and create shards of glass that were projectiles. And so the idea is that we want manufacturers to be more careful in the manufacture of an item like that because of the physical risk it poses when that item is now in consumers' homes. There's a very bright line in those doctrines between physical items that are capable of causing physical injury and intangible things or services, which do not pose the same risk of sending glass shards as projectiles because there's literally nothing like that in their possession. So the laws normally limit products liability theories to actual physical products, not to services like Internet services like Facebook. So it's a leap of the theory to try and expand it to cover services. This theory wasn't designed for that purpose. It's not optimized to do so. And unlike the regulation of Coca-Cola bottles exploding with glass shards, there's significant speech implications if we try to regulate the dissemination of information as if it's an exploding Coke bottle. So there have been plaintiffs across the country that have been trying out the theories that Internet services are subject to products liability doctrines, and courts have split on that issue. Most courts have rejected it. Some have entertained it, and so it's a live frontier in Internet law today.
And have there been rulings by appellate courts on that?
Yes and no. There's been a variety of rulings in different fact circumstances, but there's a leading case in this area that just came out in February from the Fourth Circuit. It involved a very, very similar case involving a shooter who allegedly was radicalized on Facebook, and the plaintiffs argued products liability as part of the reasons why Facebook should be liable. And in that case, the federal appellate court shut all that down and said that Facebook qualified for Section 230. Everything that the plaintiffs are arguing was trying to hold Facebook liable for the third-party content available on its service, and therefore the plaintiffs lose. So the plaintiffs in this case aren't directly bound by that ruling, but clearly there's a strong message from that ruling that the plaintiff's arguments should not be successful.
Does that issue depend on the state's product liability law? Because those laws differ from state to state.
It can. We have to look at the terms of the exact statute, what it says it covers. That might very well restrict plaintiff's claims but not expand them. In other words, there's some limit to the theory that as far as it can go, at some point it has to stop, either because of doctrines like Section 230, which Congress enacted as the way to prevent that kind of expansion, or because of the First Amendment, that the Constitution does not permit a physical-based legal doctrine to extend to the dissemination of speech.
Eric, tell us about the plaintiff's claims about the algorithms.
So in order for the shooter to get access to the radicalizing content, somebody has to upload it, and then Facebook has to make the match to present that to the reader, to the shooter in this case. And so plaintiffs have often claimed that it was the algorithm Facebook created that led to this radicalization. Now, there are a couple of problems with that theory. One is it was expressly rejected in the Fourth Circuit opinion that I mentioned earlier. Federal appellate court said that's not a way of getting around Section 230. The other piece, and the appellate court mentioned this as well, that in order for Facebook to do anything differently to prevent that radicalization, it would have to re-architect its entire service. In other words, there's not a way of it just changing the algorithm to eliminate the risk of radicalization without changing any other element of its algorithms. In other words, there's no easy fix here for Facebook. Facebook worked the way it was designed to work. It made matches between people and content they might be interested in. Unfortunately, some people are interested in content that is antisocial. Facebook's algorithm treats that the same as all other content.
If the court allows the case to go forward, will the plaintiffs have to prove that Facebook or the other platforms led to the radicalization of the shooter, and how difficult will that be?
Definitely, they'll have to show that what we call causation when it comes to negligence. I believe that will also be relevant in the context of strict products liability. And it will be difficult. And causation was also an issue in the federal appellate court ruling I mentioned from the Fourth Circuit. And the court independently said there was not sufficient causation in that case. And when we think about what causes someone to radicalize into a white supremacist, and even worse, what causes a white supremacist to then decide to engage in mass murder, there's so many things that contribute to that outcome, and it's very difficult to pull out one piece and say, that's the cause, they should bear all the burden of responsibility. In fact, it really is a whole of society failure to have people who end up in that circumstance, and we really need to look at our society across the board to figure out what went wrong and what we ought to be doing differently. And to try and pin it on any one player in the ecosystem to say Facebook was the reason why this particular person pulled the trigger, I really think kind of denies the reality of how we've all contributed to a society that can lead to these outcomes.
And explain how Section 230 would work here as a defense.
So the plaintiffs are arguing that Facebook radicalized the shooter, and Facebook itself normally doesn't publish content itself that it authored. Its primary way of engaging in content distribution is to gather third-party content, like the Facebook post that we all make as the everyday activity, and then share that with an audience. And so the content that allegedly radicalized the shooter didn't come from Facebook. Facebook at most was the mechanism by which some author matched with the shooter. And so it's impossible really to describe Facebook's role in radicalizing the shooter without talking about the content that radicalized the shooter, all of which came from a third party. And if third-party content can't create liability for Facebook, Section 230 will apply.
Is the easiest path for the appellate court here to send the case back to the trial court, saying the facts have to be developed more before we can make a decision?
So that's essentially what the lower court did. The lower court basically said, I understand Facebook's defenses, and yet I need to see more facts before I'm prepared to make the conclusion that products liability applies or even that Section 230 applies. So one possibility is that the appellate court could say the district court was right. Let's let the case continue to evolve in its ordinary manner, and once we get more information, then we'll be able to figure out what defenses actually apply in this circumstance. Most cases involving Section 230 don't do that. Most cases in Section 230 end at the motion to dismiss because it is obvious on the face there's nothing that would be produced in discovery that would show that Section 230 didn't apply. And here, I don't think anyone's contesting that Facebook provided or authored the radicalizing content. The allegation is that it matched the shooter with third-party content. So everything that the court needs to know about Section 230 is, I think, already available to it. So punting on that question actually would be a disservice to Facebook and I think to all other social media that expect to be able to avoid liability for things that they're not legally responsible for.
But it wouldn't be the first time we've seen a court punt when it didn't need to. Thanks, Eric. That's Professor Eric Goldman of Santa Clara University Law School. A note. Michael Bloomberg, the founder and majority owner of Bloomberg LP, the parent of Bloomberg Radio, is a donor to groups that support gun control, including Everytown for Gun Safety, which represented the plaintiffs here in the lower courts. Coming up, President Trump tests the appointments power. I'm June Grasso, and you're listening to Bloomberg.
Hi, everyone. It's Judge Janine. I'm at the water cooler in the United States Attorney's Office in Washington, D.C.
President Trump appointed Jeanine Pirro, the former Fox News host and prosecutor, to be the interim U.S. Attorney for D.C., taking the place of Ed Martin, who was the interim D.C. U.S. Attorney for close to 120 days. Having two successive interim appointments tests the bounds of the appointments power. It also reflects a growing trend of presidents leaning on temporary appointments for top roles. In Trump's first administration, he appointed 3 successive officials to temporarily fill the role of Secretary of Homeland Security. That practice ultimately backfired in court when federal judges found that 2 of those acting secretaries were improperly serving and struck down immigration restrictions they'd issued. Joining me is Ann Joseph O'Connell, a professor at Stanford Law School who specializes in political appointments. Will you explain the provisions that are at play when a U.S. attorney is given an interim appointment?
So when there's not a Senate-confirmed U.S. attorney in a particular district, there are 2 statutes that can provide for temporary service. So the first, what we call interim U.S. attorneys, is a specific provision in the United States Code called Section 546. And that provision allows for the Attorney General to choose a temporary interim U.S. attorney for the district in which there is not a Senate-confirmed person. There are no restrictions on who the Attorney General can pick, so they don't have to pick someone who's within the Department of Justice, unlike this other statutory provision. And so the Attorney General can pick an interim U.S. attorney, and that person can serve for 120 days under Section 546. And then after that 120 days expires, the district court may appoint a U.S. attorney to serve until there is a Senate-confirmed one.
So what happened here is the term for Ed Martin was about to run out. And before the district court could appoint someone, President Trump nominated as another interim U.S. attorney, Jeanine Pirro. I mean, is that according to the rules?
Well, it depends whether you're looking at the text of the rule or the intent of the provision. Under the text, I think it's permitted. The provision, Section 546, does not explicitly bar successive 120-day appointments. And I should also note that even if the district court had chosen someone, the president, in all likelihood, could have fired the district court pick and picked another interim U.S. attorney or turned to this other statute, the Federal Vacancies Reform Act. So I think the text permits successive appointments. There's no explicit bar on it. And in the past, we have seen successive appointments. Now, that's the text. When Congress reimposed time limits, so put back the 120-day constraint on how long interim U.S. attorneys can serve, they did that in 2007 after a U.S. attorney scandal involving Attorney General Alberto Gonzales, who had fired a number of U.S. attorneys. And the scandal was not whether the president or the attorney general could fire U.S. attorneys. It was about the reason that was given for those firings. But at the time that it happened, there was no limit on how long interim U.S. attorneys could serve. And there was a period of years where there was kind of no time limit. But then in 2007, Congress put back this time limit. And I think the putting back of the time limit suggests strongly that the intent of Congress was not to have endless interim appointments of U.S. attorneys.
Was that the intent of the framers as well? In other words, they wanted the Senate to advise and consent?
So we have had Senate-confirmed appointments since the start of the United States Constitution under the Appointments Clause. And interestingly, we've had statutes that provide for temporary appointments from about the same time. The very first Vacancies Act, which applied generally, was in 1792, and there was another one in 1795. There it gets a little tricky about kind of what were the time limits, because in the 1795 Act, Congress imposed a 6-month time limit on acting officials.
You hear a lot of actings. Have U.S. presidents been using interim positions more and more?
So I have done some research on recent administrations and looking at the very highest level of positions, so the heads of agencies, cabinet secretaries in particular, and definitely recent administrations, and that would include President Obama, President Trump's first term, and President Biden have heavily relied on acting officials, much more, I would say, than their predecessors in terms of modern government.
What's the reason for this? I know that President Trump in the past has said, he likes the idea of it. Is it because it's difficult to get people through the Senate? I mean, what's the reason that they're using it more?
I think there are several reasons. The first is it takes time to nominate people, though I will say that President Trump in his second term has a much faster nominations pace than he had in his first term. I mean, 6 or 7-fold more nominations at the 100-day mark in his second term than in his first term. But nominations still takes time to find the people and to formally nominate them. There's a vetting that occurs. And I think for President Trump, that vetting has really focused on loyalty, whereas in other administrations might be focusing on ethical considerations, expertise, and the like. And then there's the confirmation process. And so even as we have now, and even as we did for President Biden, have a Senate controlled by the same party as the White House, it still takes time because individual senators, even though there's no longer a 60-vote threshold to move a nomination to a confirmation vote, that went away in November of 2013, individual senators can still delay the confirmations process. Right. And we saw this with Senator Tuberville in the Biden administration. We've seen this in other cases as well. Right. Democrats do it to Republicans. Republicans do it to Democrats, and that can slow it down. And so I think both the nominations and confirmation process make acting officials attractive. But I would also say that what I think is a large reason is that acting officials don't require Senate confirmation. And so you can pick people to serve in a temporary capacity that the Senate might not confirm. So in President Trump's first term, the Republicans, as reported by the media, did not want to confirm Ken Cuccinelli to a senior post in the Department of Homeland Security. But through acting appointments and delegations of authority, Mr. Cuccinelli was able to serve in very high-profile roles in DHS. And I think a similar story for Ed Martin, that Republicans balked, and he was able, through the interim provision, to serve, whereas, if he had just been put up as a nominee, not as an interim, he might not have gotten through.
Has President Trump pushed the limits of the Vacancies Act further than other presidents?
I think the Vacancies Act is pretty capacious. It allows the government to function. I think the Vacancies Act should be reformed in certain ways because I think it allows more than perhaps what we want for an accountable government. But I think in this term, President Trump is really pushing an argument that no previous president has pushed, which is that he believes that if the Vacancies Act does not apply, he has inherent Article 2 authority to name acting officials. And this has come up in the Inter-America Foundation and the African Development Foundation. These are entities not covered by the Vacancies Act, where President Trump has named acting officials to Senate-confirmed board positions, relying on claimed inherent Article 2 authority. It seems with the firing of the Librarian of Congress that if the Library of Congress is not subject to the Vacancies Act, and I don't think it is, President Trump, the White House has indicated that there is Article 2 authority to name an acting librarian. And I think this is an outrageous claim. We have an appointments clause. We have a recess appointments clause. It is true that the Vacancies Act and specific agency provisions like Section 546 for interim U.S. attorneys do allow vast use of temporary appointments, but outside of those, presidents need to rely on the appointments clause or the recess appointment.
Some legal experts have suggested that defendants who are prosecuted by a successive interim U.S. attorney like Pirro could challenge their prosecutions based on claims that she's serving in the role improperly.
I think they would definitely have standing to sue. And I think their argument would be that under Section 546, successive 120-day appointments are not allowed. And I think that is a plausible argument. I just don't think it's a winning argument. I think that courts will look at the text, right? As Justice Kagan says, we're all textualists now, that the courts will look at the text and see that successive 120-day appointments are not barred. It's happened in the past and permit it. Now, that doesn't mean it shouldn't change. I mean, Congress could amend 546 to make it clear that you get one 120-day appointment, then the district court gets to choose. And then I should note that there is an alternative to these successive 120-day appointments while a nomination might be pending to a U.S. attorney slot, is that I believe that the Federal Vacancies Reform Act is available for temporary appointments to these positions. Now, the constraint, why I think the Trump administration doesn't want to turn to the Vacancies Act, is that under the Vacancies Act, you can't just choose anyone. You can't choose an outsider like the current person. You can't choose an outsider to come in as an acting U.S. attorney. You either need to choose someone who is the first assistant to the U.S. attorney, right, which is typically a career person. You need to choose someone who is Senate confirmed already to another position, so has already kind of gone through the Senate process, or you have to choose someone who was in the agency for at least 90 days in the year before the vacancy.
So finally, you think there needs to be reform here?
I think the laws governing temporary appointments are pretty broad and likely too broad. On the other hand, we want the government to function. We don't want the government to come to a standstill. And so finding the balance between getting Senate-confirmed appointments through a dysfunctional appointments process and having the government function is tricky. And sometimes we're on the right side of the balance, and sometimes we're on the wrong side of the balance. And so I think that Congress really has a role to play in constraining the use of acting and interim appointments.
Well, a study on vacancies showed that President George W. Bush didn't nominate anyone in 13% of vacant Senate-confirmed roles in federal agencies. President Barack Obama didn't nominate anyone in 15% of those roles. And President Trump in his first administration didn't nominate anyone in 26% of those roles. So it's a growing trend. Thanks so much, Ann. That's Professor Ann Joseph O'Connell of Stanford Law. And that's it for this edition of the Bloomberg Law Show. Remember, you can always get the latest legal news on our Bloomberg Law podcast. You can find them on Apple Podcasts, Spotify, and at www.bloomberg.com/podcast/law. And remember to tune into the Bloomberg Law Show every weeknight at 10 p.m. Wall Street time. I'm June Grasso, and you're listening to Bloomberg.